appeal in the Macur case in Zimbabwe and the Secretary of State for the Home Department.
Hello, my
Mr.
lords.
Jones.
I appear for the appellant in this matter. My own friend, Mr. Malik, appears for the Secretary of State. We are just awaiting the appellant, but there's no reason why we can't obviously proceed.
I think we should start.
Oh, absolutely.
If you don't mind, Mr. Jones, but have you received any information to say he's nearby or anything like that?
We haven't, no.
So we'll proceed. I'm sorry he's not here, but there are lots of difficulties. We understand that.
Of course.
Okay.
Lady, I have, because I'm very conscious of the amount of time we have, because there is quite a lot of ground to cover, I have prepared a detailed speaking note that I'd be very happy to hand up, which I think may assist the court to progress through my submissions a little bit more expeditiously.
And has Mr. Malik seen it?
I've shared it with my own friend only this morning.
All right. Well, if you'd be doing nothing more than reading from it, I don't think, Mr. Malik, we're going to gain any. You're going to have any disadvantage, or Mr. Jones is going to gain any advantage from that. So
not
it
at all.
does seem helpful.
Absolutely.
Save the pen anyway, won't it?
Absolutely.
Yes. All right, Mr. Jones.
Thank you, Lady, I've also prepared two schedules, which again, because the density of legal factual findings by the upper tribunal and the first tier tribunal, over 60 pages of reasoning on the particulars of these cases, I thought it might be helpful to prepare schedules of the specific findings that the respective tribunals recorded on particular issues such as private life, family life, rehabilitation, and so forth. Now, it's primarily for a reference source for the court, perhaps after the hearing.
Yes.
But again, I thought that might assist to at least in terms of your formulation of judgment in due course. So, with your permission, I'll hand up what's essentially 3 documents.
Thank you very much, Mr. Jones. You've obviously been very busy.
We will post all of these documents in Word form on the OneDrive account, which the court has
Yes,
access.
thank you. Thank you very much. So where do you want to start then, Mr. Jones?
Beginning, I think it's usually the best place, with my speaking note, if I may, and just to introduce the format of the submissions that I'm going to make to the court this morning. So I propose to address we say there are 3 aspects of the upper tribunal's disposal that need to be reviewed by the court. The first is its conduct and management and disposal of the error of law procedure. Second is its actual procedural management of the reconsideration process and the parameters of that reconsideration process, which we say were impermissibly extended beyond that which the appellant understood them to be. And third, the third step, and I've enumerated these steps in the first section of this speaking note, the third step is an evaluation of the legality and the indicators of perversity within the reconsideration decision itself.
That's very helpful, Mr. Jones. Just to be clear, you presumably accept the summary of the law that the upper tribunal set out in paragraph 14. You remember those 10 short paragraphs. And this appeal really is about, as you say, the procedural aspects and the facts and the way in which the upper tribunal approached that task.
That is certainly the focus of the argument in the second 2 steps, the reconsideration and the management of reconsideration, and then the actual disposal of the reconsideration substantively. With regard to the upper tribunal's decision-making in respect of the error of law and the determination to proceed on to a reconsideration, we say that there are issues within its disposal there which are matters for this court with regard to the construction of, in particular, section 117b(5) of the Nationality, Immigration and Asylum Act 2002. And indeed, that is how we have, the skeleton argument we put before the court broadly reflects the way that we're putting the case.
Indeed. As I understand your first point, it is that the the upper tribunal shouldn't have proceeded in the way that it did, could either have remitted or remade. And you say that the way they went about that task
Yes.
was wrong in law.
Yes.
But as regards the summary of the law, this is the basic law in this area, which has been worked over quite a lot of times. You would accept, would you, that the summary that we got in the upper tribunal second judgment, paragraph 14, is...
Is it paragraph 18?
Sorry, it's paragraph 18, forgive me,
Yeah.
thank you. Paragraph 18. You wouldn't take issue with any of that?
I'm very familiar with what is recorded there, and I take no issue with the way that they frame the exercise that should be performed by a court when looking at the assessment of whether there are very compelling circumstances. Save that, we do say, as a primary submission at the first step, that the section 117b(5) introduction by the First Tier Tribunal, which I'm sure that the panel will be aware, would underlay the First Tier Tribunal's determination to dismiss the appeal, stated in very clear terms that but for the necessity
I think you're going one step ahead of my Lord's question. It's okay, Mr. Jones. I think if we get the base work fine, then we can go on to say why you think that it was incorrectly applied. But paragraph 18, and then the electronic bundle, it's at page 28 onwards. My Lord's point is that appears to be a fair summary of the relevant law. And of course you're going to go on and say, well, this is why they went wrong thereafter. But as a first step, do you agree that that is an appropriate summary?
I'm content that that, broadly speaking, is accurate with regard, as I said, to the assessment of very compelling circumstances.
Right.
And I will make observations in due course as to where subsequent decisions of this court in particular may impact on that
we understand.
Summary. I'm sorry, Lord, for going around the houses.
No, not at all.
I hope that answers.
Very helpful, thank you.
So with the court's permission, if I could take you to the first page of the speaking note. And I have described there the 3 steps that I propose to take the court through. And I've also signalled what we say in the event the appellant was successful, what the outcome would be for this appeal in the event that you would find for him at any one of those 3 steps. That's the first passage at the top of the speaking note. We say, were you to find for us in respect of step 1 to the effect that the upper tribunal should have concluded either that section 11b(5) of the 2002 Act had no application, or on the facts as found by the First Tier Tribunal should have been found to have been settled, the appeal should be allowed. If, however, do not find for us on that front, but found for us either on the basis that the reconsideration was conducted in a manner which was unfair, step 2, or there are aspects of the substantive disposal which were unlawful or perverse, step 3, then we would say that the outcome of a successful appeal would be remittal to the upper tribunal. And that's particularly in recognition of the fact that a significant amount of time has now passed since the determination of the upper tribunal's the reconsideration. As this court appreciates, assessments of matters of fact in respect of human rights issues must be conducted at the date of the disposal, and so it's more appropriate that the matter be dealt with again by the upper tribunal in the event that we were successful at those points. So there is an issue raised by my own friend in his skeleton with regard to the operation of section 12 of the Tribunals Courts Act. I just wanted to outline very quickly what the appellant's position is as to what should have happened at the error of law hearing. We obviously necessarily accept that there were errors of law in the First Tier Tribunal's disposal, but those errors were extremely narrowly drawn, and in the second schedule that I've handed up to the tribunal today, this schedule is entitled Errors of Law, the Error of Law Determination. It's 3 pages long.
Shall we call that Schedule A?
Yes, maybe. Thank you.
This is errors of law findings.
That's correct. Yes. You if the court would just turn to the final page, page 3 of Schedule A, you'll just see at the top, first entry, the 2 errors of law that the upper tribunal identified.
And you do?
Well, I argued for them successfully, so I think it would be unwise of me to suggest that they got it wrong. So they were right to find errors of law on those specific issues in respect of the First Tier Tribunal's determination. The question then was, what did they do with that determination, having identified those errors? And our position was that those mistakes only were in one direction. Recognition of those errors should have caused a properly directed tribunal to conclude that the appeal should have been allowed in accordance with the opposite direction that the First Tier Tribunal judge gave to himself.
The paragraph 141.
Indeed, Lord.
And your beef is that they either should have done that or omitted?
To the same judge, ideally, would have been the sensible thing to do, given the very comprehensive nature of his findings and the very particular nature of his mistake. And I have, to assist the tribunal in the other aspects of Schedule A, outlined the numerous points within the upper tribunal's error of law determination where they expansively complimented the First Tier Tribunal on the comprehensive, thorough, and legally accurate manner in which he disposed of this appeal at the first instance.
But, Mr. Jones, we've got a situation whereby this upper tribunal, in reaching the determination that there had been an error of law, were then faced with 2 ways forward. And you've got to establish, as the appellant, that the route they chose was wrong. And aren't you in a little difficulty there? Because both were available to them. They indicated that they thought it appropriate to retain the case, to rehear the case, and preserve the hearings of the First Tier Tribunal. So how are you going to get around that procedural decision which was open to them?
By demonstrating, my lady, that the foundation upon which they fixed or identified the necessity to make further findings of fact was a legally flawed foundation, because there was either as a matter of law or as a matter of fact no necessity to perform a further evaluation of the critical fact. Critical fact, my lady, is again set out for your assistance on page 2 of Schedule A. There is only one element of the factual findings that the upper tribunal in the error of law hearing identified as potentially deficient with regard to the First Tier's disposal.
Yes, but then it has to be placed into a landscape, doesn't it? They don't just have to go to that one moving picture, as it were. They look at the landscape and say, well, if that has not been formulated as it should have been, we need to reformulate it, or we can reformulate it. And in doing so, it may then cast a different shadow on other facts that were found in the First Tier Tribunal.
That's certainly how the upper tribunal approached the matter.
They did.
But with respect, it was not.
But why is it wrong?
The right approach.
I mean, it might not have been your favoured approach, but why is it wrong?
It's wrong, as I'll seek to persuade you when I take you through step 1. It's wrong because, number 1, Section 117b(5) of the 2002 Act should not be regarded as applicable in instances where, as in this case, the exception with regard to private life in Section 117c(4) of the 2002 Act operates.
So that's your point. Shall we get on with it?
Let's do that. Lady, thank you. I am assisted by the questions, though. It does help me to understand what is.
It's not hostile fire at all, Mr. Jones. It's to assist our understanding too. But we need to get on, I think, to the actual issues rather than to compliment, as the upper tribunal did, the First Tier Tribunal in certain respects, but not in others.
Just to be clear on that proposition, Mr. Jones, you said that Section 117b(5) is not applicable where Exception 1 operates.
Where Exception 1 in Section 117c operates, that's 117c subsection 4. We say that the general rule that private life should be treated as precarious, which is set out in 117B, should not operate. I offer two different bases for that. So we're going to take the court to page 2 of the speaking note.
Yes.
Now, the court can tell me to move on at any point if I'm speaking to the converted with regard to what the statutory purpose of Part 5A of the 2002 Act was about and how comprehensively deficient the drafting of those sections have been shown to be persistently. But I'm going to take you through that until I'm told to stop. And so very briefly, if I could take you to paragraph 10 of the speaking note on page 2. The statutory purpose, the Parliament's purpose, as is now understood with regard to Part 5A, is to produce a structured approach to Article 8, which enabled clarification of Article 8 issues for assessment and would encourage consistency and predictability in assessments by the tribunal. And also, expressly, would reduce the scope for the exercise of judicial discretion. And we can find that, first of all, in the Supreme Court's decision in KO, which is in tab 5 of your authorities bundle. And if I could take you, my lady, my lords, to tab 5, and in particular to paragraph 12, first of all, which appears at page 110, my lady, of the electronic version.
Say paragraph 12.
Yes, ma'am. Everything should be sidelined, I hope, to assist the court. It's at page 110 of the bundle of authorities, which are numbered at the bottom.
Yes.
And it's really, for our purposes right now, it's the second element of that passage. Just read it to you, the court. Beginning the background to those changes. The background to those changes explained by Lord Reid, JSC, paragraphs 19 to 21 of the decision in Hesham Ali. Their avowed purpose being to promote consistency, predictability and transparency in decision making, and to reflect the government and Parliament's view of how, as a matter of public policy, the balance should be struck. And then if the court would just step down to paragraph 14 and 15. Paragraph 14, the court is berating the construction of Part 5A. As Part 5A of the 2002 Act takes that process a stage further by expressing the intended balance of relevant factors in direct statutory form. It is profoundly unsatisfactory that such a set of provisions, which is intended to provide clear guidance to limit the scope of judicial evaluation, should have led to such disagreement amongst the most experienced Upper Tribunal and Court of Appeal judges. And that was in the context of, obviously, to what extent public interest considerations were factored into the evaluation of the best interest of the child for the purposes of a reasonableness or unduly harsh assessment under the exceptions in 117B and 117C. And the court then goes on at paragraph 15 to state, I start with the expectation that the purpose is to produce a straightforward set of rules, and in particular to narrow rather than widen the residual area of discretionary judgment for the court to take account of public interest or other factors not directly reflected in the wording of the statute. I also start from the presumption, in the absence of clear language to the contrary, the provisions are intended to be consistent with the general principles related to best interests of the children, including the principle that children should not be blamed for matters which he or she is not responsible, such as the conduct of the parent. And there's a similar but also helpful reference to the purpose in the decision of the Supreme Court in Rupiah, which appears in the authorities bundle at tab 4. And it's page 93 of the authorities bundle, paragraph 36. And there the court is referring to the reasoning of Lord Justice Sales, as then was in the case of Rupiah before the Court of Appeal, and says this, in paragraph 45 of his judgment, the present case, Sales LGA recorded that it was common ground, the starting point for consideration of the proper construction of Part 5A is that sections 117A to 117D are intended to provide a structured approach to the application of Article 8, which produces in all cases a final result which is compatible and not in violation of Article 8. Goes on, this remains common ground is clearly correct. As far as legislation is intended in all cases to produce a result compatible with the article, we will need to find somewhere within it provision for a degree, no doubt, limited of flexibility. And that emphasis appears throughout case law concerned with these provisions. The underlying purpose of these provisions is to focus and enable consistency, remove residual discretion, but also to ensure, nonetheless, that decision-making of the courts remains compatible with the jurisprudence of Strasbourg on the application of Article 8. And I have, within the speaking note, afforded other references at the bottom of paragraph 10 to similar comments in other cases, if the court wishes to make reference to them. Now, as I said previously, that Part 5A is poorly drafted is not only confirmed by the way that the Supreme Court made its observations in KO, it's reflected repeatedly in other judgments, both of this court and of the Supreme Court. For instance, if one turns up, if you're still in tab 4.
The purpose of emphasising this
is to say, my lord, that I'm inviting this court to recognise another deficiency effectively in the framing of that, of those statutory provisions, which is essentially one which enables, we say incorrectly, the importation of the general rule at 117b5 into the specific exception at 117c4.
So shall we proceed then on the basis that, unless Mr. Malik seeks to argue otherwise, that Section 5A is poorly drafted, you now want to create a new interpretation of certain factors, and it's, rather than take us to other authorities where we're going to see similar comments to those of Lord Wilson and Lord Reid, shall we go to the point?
By all means, but there are there for your reference.
But I think, speaking for myself, I think we're all very well aware of the problems that this has caused. So we don't need detail on it.
I'm grateful for that indication. Well, you have the references there should you want to go to them. They're all in paragraph 11 and 12. We step on then. What we say should have happened with regard to the interpretation of section 117b is then dealt with at paragraph 14.
Yeah.
But before we get into that, it's just helpful to kind of frame that evaluation by reference to what 117b5 and 117c4 were concerned with. So with regard to the application of 117b5, I don't think we need to dwell on this, paragraph 14. The position is that although section 117a to small a says that the provisions in 117b apply to all cases, the fact of the matter is that there are numerous authorities which speak to the fact that they do not, in particular in the context of cases where the specific exceptions, both in 117b6 and 117c4 and 5 operate. Again, I don't think we need to dwell on that. The relevant references are set out in paragraph 16 of the speaking note, and I think my own friend does not take issue with it, and indeed I think it's one of the legal principles, my lord, that were identified at paragraph 18 of the Upper Tribunal's reconsideration. So it is not an answer to the submission I'm going to make that 117a2a of the statute says that the provisions of precariousness in 117b applies to all cases, because as a matter of fact it does not. Now, for the present purposes, the limitation of the operation of that exception is essentially confined, that provision is essentially confined to the specific exceptions within statute with regard to family and private life, for our purposes, which are detailed in 117c4 and 5. And then beyond that, that detailed in Rupiah, with which this court is no doubt familiar at paragraph 49, where the court endorsed the proposition that there was scope for a degree of treatment of exceptionality in the context of particularly strong features of private life. Now, So, starting from that position that it's already been identified that there is scope for accepting individuals from the operation of that general provision, we go in then to look at what Section 117C4 is all about. And what we say Section 117.4 is all about is essentially the formal inclusion within statutory context of the principle that was outlined by the European Court of Human Rights in the case of Maslov. That is the underlying focus of that provision. So if I could take the court to
where are we in your note?
paragraph 21.
Can you just keep us up to date as to where you are in your note? That would be very helpful. Thank you.
So it might assist at this point just to turn up the...
So it's paragraph 26, in fact, in your note.
So actually, if I could just keep you at 21 for a moment. If we could go to tab 26 of the authorities bundle, which is where all of the statutory provisions in Part 5A are contained. It's page 584 of the authorities bundle. Again, I don't doubt that the court is very well familiar with these provisions, but just to frame what we're about to discuss. So first of all, at page 584, we have section 117A, which is the provision which outlines how the Part 5A operates. And the relevant part of that is paragraph 117A, subsection 2. There it's expressed in terms that the 117B provisions apply to all cases, and in the context of deportation, the considerations listed in 117C also have to be applied. You then step on very briefly, just to inform this discussion, you'll find on the subsequent...
But it also says must in particular have regard to.
Yes.
11C.
Yes.
117C, sorry.
There is no contest between the parties as to the
No.
necessity to do that.
No.
And indeed that it's been done, but we say imperfectly by the upper tribunal.
Yeah, I'm just picking you up because you missed out the part of the statute.
You're right.
I'm sure Mr. Malik will draw our attention to it in due course.
Of course. Right, if you just step through to the next page, you'll see the relevant provision for the purpose of 117B set out at subsection 5.
Yeah.
Little weight should be given to the private life established by a person at a time when the person's immigration status is precarious. That's the provision that the First Tier Tribunal concluded compelled him to dismiss the appeal ultimately. And then we go on to 117C, and the exception with which we're primarily concerned is at subsection 4. Exception 1 applies where it states C has been lawfully resident in the United Kingdom for most of his life, which is accepted here by the respondent and the tribunal. B, C is socially and culturally integrated in the United Kingdom, also accepted here. And C, there will be very significant obstacles to C's integration into the country to which C is proposed to be deported. Again, accepted, and in this instance, accepted to a significant degree.
And then subsection 6.
Yes, Rod. So in the case of foreign criminals who have been sentenced to a period of imprisonment of at least 4 years, public interest requires deportation unless there are very compelling circumstances over and above those described in exceptions 1 and 2. So the first point we make by reference to section 117C4 is that Parliament has seen fit with regard to the operation of that exception to specify, and this is paragraph 22 of the speaking note, the lawful condition for eligibility. And it is specified to be lawfulness. And that is a status which can be understood to operate discretely from settled status, which is, as we know from the decision in Rupia, settled status is the only form of status which is capable of, under 117B, of removing one from the definition of precarious. The second point, paragraph 23 now of the speaking note, we say that in formalising in the exception the status that leads to the application of the exception. It was an intentional act by Parliament. And what it did was it liberated certain categories of Article 8 applicant from the constraints of Section 117b(5). So it enabled lesser forms of leave to facilitate qualification under the exception, which is critical when we know that when the exceptions are met and you're a medium offender, there is no further evaluation of public interest considerations outside of what's contained within the exception. If the court would turn over to page 4 of the speaking note, in paragraph 25. As I alluded to already, by formalising the status required for inclusion within the exception, Parliament has essentially disapplied Section 11b(5) for the purposes of medium offenders.
Is there necessarily a conflict between 117b(5) and precarious? You can be lawfully resident, but still precarious.
That is correct, my lord, but for the purposes of the operation of the exceptions, if one brings oneself within the exceptions and is a medium offender, there is no reversion back to the question of precariousness. That's the point I'm seeking to make, not that there is a distinction between lawful status and precarious status.
So I'm speaking for myself, I don't follow that. You say it's a one-way street. Once you're into exception 1, you can't look back to 117b(5). Is that your point?
That for the purpose of a medium offender, that is the situation. It's outlined in paragraph 31 of the speaking note, and I don't think it's a point of controversy.
Right. But for the purposes of a non-medium,
yes, your Lordship is right. On the ordinary understanding of the system at the moment, and this issue has not been engaged with anywhere by the court to date, the submission that I'm making to the court. At present, the position would be for a serious offender that all matters are open. What I'm seeking, including...
But we're not dealing with a medium offender here, we're dealing with... So how does this help you?
I'm saying, my Lord, that the way that one approaches the assessment of very compelling circumstances for serious offenders who fit within the exceptions, then that exercise should be guided by the fact that you fit within the exceptions. And that guidance should include the exclusion of precariousness from the evaluation. And I'll explain why that is an appropriate course of action. I mean, we say that that's the appropriate course, my Lord, essentially by reference to the very principles that we've already looked at with regard to how this Part 5A is supposed to operate. It's supposed to facilitate straightforward evaluation of Article 8 considerations in a structured and coherent manner. It's supposed to limit judicial discretion, and it's supposed to guide the decision maker to arrive at a conclusion which is compatible with Article 8.
It isn't to limit the discretion, is it? It's to guide the discretion. And if we look at 117C6, as my Lord has invited you to, isn't the difficulty you've got that there's an express requirement that in the case of a foreign criminal who's been sentenced to a period of imprisonment of at least 4 years, the public interest requires deportation unless the very compelling circumstances over and above those described in exceptions 1 and 2, it is removing the serious criminal from the medium criminal. As you
and I completely accept that, my lady, but it is also speaking to decision makers and saying, be guided by the exceptions as a starting point for your evaluation of very compelling circumstances.
Well, that's not what it says. Well, that's not what it says.
It's saying something over and above the exceptions. And what all of the authorities...
Well, no, it doesn't say over and above. It says, unless there are very compelling circumstances over and above those described.
Yes.
So why would that then take you out of subparagraph 5 and the precariousness?
So, lady, what we say, this is one of the points that we make, is that, again, to comply with the structured approach that Parliament intended, and looking at the wording of Section 117C6, the starting point for an evaluation of very compelling circumstances should be the exceptions. And there is numerous authority supportive of that proposition. And if the court turns...
The way you put it is the starting point is as to how you look at very compelling circumstances. But surely what Parliament has done here is said that there's 2 stages to this. Number 1, criteria. You have to bring yourself and prove you're within the exceptions. And then in addition, over and above, you have to satisfy this even higher test. So in a sense, struggling a bit to understand your approach, because you appear to be suggesting that the tail's wagging the dog, that somehow the starting point governs the rest of it. But this is a 2-stage test with criteria which Parliament says have to be fulfilled, which is a different matter, isn't it?
The position is this. What we're saying is that in instances where a serious offender is recognised by the tribunal in an evaluation of very compelling circumstances, which is guided by the exceptions to start with, and then necessarily an evaluation of matters over and above those exceptions afterwards. Where a person brings themselves within the exceptions, as this appellant has, the fact that they are within the exceptions is material to the evaluation that is subsequently performed of very compelling circumstances. Not only is it material because it speaks to the decision maker to say, well, Parliament has described these as exceptions, as significant matters in the context of Article 8, which are actually definitive with regard to the illegality of deportation for anyone with a sentence of less than 4 years. So they're absolute. So if you're in that category, the conversation is finished. So they're important in that context because they're persuasive as to the weight that should be attributed to Article 8 considerations. But beyond that, we say that they're material also because they offer guidance as to, in particular, the form of status, which is immigration status, which is capable of impacting upon, in this instance, private life in the context of the subsequent review of very compelling circumstances.
There may be a sine qua non for the purposes of serious criminals, exceptions 1 or 2. But that is, and they may be relevant to the holistic, and we'll be coming to that analysis that the courts are required to do, and there's lots of authorities on that. But I'm still struggling to understand how it is, in the sense you say that exceptions 1 or 2 are effectively a straitjacket to the operation of the additional requirement in subsection 6 for very compelling circumstances. And secondly, I'm still struggling to understand why you say that once you are within exception 1A, lawfully resident, that you cannot be lawfully resident but still precarious. Could you help me with both of those?
I'm in no way saying that decision makers are straitjacketed with regard to the evaluation of very compelling circumstances in the context of the public interest factors going to offending risk, to deterrence, and to the limited extent that expression of revulsion is still a material consideration in that context too. There is no constraint, and I say this clearly in the speaking note, the effect that the public interest in the offending side of the equation is not altered by the submission I'm making. What I'm saying, what the submission we're making is that the immigration element of the evaluation is affected by inclusion within the exception. So the extent to which it is permissible or appropriate for the tribunal to revisit issues of status, the quality of status and the precariousness of status when evaluating the substance of private life in the context of the very compelling circumstance assessment, that is impacted upon by an individual's facility to include themselves within 117C4. And we say...
And the answer to my Lord's point, why can you not be lawfully resident, precariously resident?
Well, the first submission we make, and if I can just find my point in the speaking note, might assist. I apologise, I'm not directing you to it consistently. If you could just bear with me for one moment. If I could take you back for a moment to paragraph 26. So our opening submission is that the way that section 117C4 is framed is principally in recognition of the principles adumbrated in cases such as Una and Maslow, and for our purposes it's convenient just to look at the case of Maslow. And if I could take you to tab 3 of the authorities bundle, I can, if you like, confirm the parallels by just reference to the language of Maslow itself. And so tab 3, the relevant passage is on page 70 of the authorities bundle, paragraph 71. Page 70, so it's just at the bottom of that page, paragraph 71. In a case like the present one, where a person is to be expelled as a young adult who has not yet founded a family on his own, which is not our case, but the relevant criteria are the nature and seriousness of the offence committed by the applicant, the length of the applicant's stay in the country from which he or she is to be expelled, the time elapsed since the offence was committed and the applicant's conduct during that period, and the solidity of social, cultural and family ties with the host country and with the country of destination. And I think if one were to put that paragraph alongside section 117C4, one could instantly see the parallels.
But how does that help you? Everybody knows that, in the sense that the 117C4 was intended to encapsulate those sort of general principles.
Indeed. It helps me, my lord, because in respect of the application of this principle with regard to young adults and people with long residence, this court has been utterly clear, and indeed the whole purpose, one of the principal purposes of the error of law hearing in this case, was to confirm that settled status is not a prerequisite to inclusion within.
I think we're violently agreeing with you, but my lord's question is why is it that lawful residents cannot, in certain circumstances, also be precarious?
Maybe the answer to it is this. If 117C4A and B and C, if they are all about introducing this particular, a protection for this particular category of applicant, and if it is established, as the section itself identifies, that to qualify and to acquire substantial weight to a private life established based on long residence as a young person, all that is required is lawful residence and not settled status. And if these provisions are intended by Parliament to be compatible with the guidance of the European Court of Human Rights, then it would be inconsistent with that objective to disapply the question of lawfulness for those who are serious offenders.
But nobody's suggesting, are they, that you disapply the lawful residence aspect. Once you pass through the threshold, then there's the separate criteria of very compelling circumstances. And why is it that in... start again. Exception 1 simply requires lawful residence. If you pass through that, then if you are a medium offender, you're home and dry. why cannot it be said that Parliament wanted to have a bright line, in a sense, and carve out really serious offenders, and therefore, as it has done under 6, add this extra criteria where the court can look at all the circumstances. In a sense, I think I understand. You say it's baked in at the exception 1 stage.
Yes.
And once you're lawful, you're lawful. But another way of looking at it is, well, you may be lawful under exception 1 as a medium, but you may be lawful and precarious, but it doesn't matter.
That's
your point.
how we say it.
Indeed, but
it shouldn't matter. It should not be weighed in the very compelling circumstance assessment that your status is precarious, because
Parliament has decided that even if, as long as you're lawful, then you get home if you're a medium.
Yes,
that's... And it really, but can it be said that on the back of that Parliament therefore intended to disapply or require the court to ignore 117(b)(5)?
Well, this is part of the reason why I wanted to dwell a little bit, but I'm not going to take you back to it.
And it's that leap that I
understand what your lordship is saying.
I find it difficult as a matter of language.
It's the difficulty with these provisions generally, is the imperfections of the way that these provisions are framed, which has necessitated this court and the Supreme Court really consistently having to interpret what was
kept the bar on the judiciary, this sort of drafting, very occupied for many years. So this isn't the only bit of legislation, but
it certainly it has produced, I think, a disproportionate amount of judgments from this court and from the court above. But the reason why, so the first reason is absolutely this court should look at these provisions and seek to interpret what it was that Parliament intended. And when one looks at these provisions properly and looks at them in the context of what it is that Parliament is purporting to do in section 1174, C4, which is to import the Maslow principle and import the proposition that for this category of individuals, lawfulness is not a consideration. And one should carry that through to the 117C6 evaluation. That is in no way inconsistent with a proper interpretation of the purpose of these provisions. It is actually more consistent with that position, because what it does is it is true to what Maslow is saying. And what we know is that Maslow does not. The Maslow principle, the additional caution that one must apply when dealing with young people and people with long residence, particularly in childhood, there is no constraint on the application of that principle by reference to the seriousness of the offence and the length of imprisonment. Nowhere in Maslow or any other decision, I'm sure Malone Friend would have drawn your attention to it, is the European Court saying this principle applies except up to the point of 5 years, 6 years, 7 years, 8 years, 9 years, 10 years, and on. That's not how it works. One must evaluate by reference to the facts of the case, not by some arbitrary cut-off that in this instance Parliament has fixed. So if one is going to be true to that principle, then one does not import the precariousness of status back in at 117C6. One recognises that question as having been settled by inclusion within the exception.
If in fact, if you have two claimants, one is a medium, one is exception, both with very similar situations, if in fact both are resident lawfully but are precarious, the medium under exception 1 gets home. Your submission is that the fact of the precariousness cannot be a criteria, a consideration at all. Is that right? In relation to the holistic analysis for the serious?
Not if these provisions are going to be consistent with the guidance of the European Court. And as I said already, that does not it is not inconsistent with what 117C is all about. 117C2, which speaks about the additional public interest which operates in respect of very serious offenders, that is unaffected by the submission that I'm making to this court. And all that 117C is saying to decision makers is the focus should be upon the offending in the context of serious offenders who fit within the exception.
Looking at 117C6 though, one of the factors which might be taken into account in determining whether it's very compelling circumstances over and above might be, might it not, that the residence wasn't just lawful but was settled.
That would be a factor which may weigh in the scale to an extent on the positive side of the equation, but it is not, the absence of that should not weigh.
But why not?
Well,
because you can't have your cake and eat it is, I think, my lord's point.
Why not? Is because that would not be consistent with the principles enumerated by the European Court, which is that it is the lawfulness of status that matters, not the possession of settled status, a position that's acknowledged by this court in Haddon-Cave.
But Parliament has said that precariousness is a factor.
But we also know that what Parliament has said about precariousness has been disapplied in other instances in very specific circumstances, in particular by reference to the operation of these very exceptions. The only distinction is that they are not expressly disapplied for serious offenders. So Parliament is not being clear. We should be focusing on the purpose of these provisions and not on the formulation of them, the articulation of them, because it is imperfect.
But you don't dispute, though, do you, that precariousness is generally a factor under 117B?
It is generally a factor, save in instances where either the exceptions in 117B6 operate or the exceptions in 117C4 and 5 operate. And in any of those instances, it is disapplied.
The point is, that why, when it's generally a factor, when you come to consider a general consideration under 117C6, why should it then be excluded?
We just come back to my submission, my lord, that if 117C4 is about effectively importing the principles of the European Court, in particular with regard to mass law, then immigration status should, save that it must be lawful, should not be a consideration which impacts materially on that evaluative exercise.
What's the answer to my lord's earlier point? That okay, you in your case you ignore it. Well, you then can't add into the equation that there is settled status, because it must work surely both ways if your submission is correct.
Well,
because you said to me earlier you ignore it altogether at this stage of the analysis for a serious offender.
It's not material in the sense that consider. It is a factor which it's an additional factor which would weigh favourably in the evaluation. I'm simply saying that there is a line drawn with regard, and the line is lawfulness. And the further you progress beyond that state, that condition into settlement, that is a factor that can impact positively on the evaluation. But it isn't. But the absence of that status is not one that impacts negatively.
But how does that work as a matter of language if, on your analysis, it's either a factor or it isn't, surely?
Because one is guided by the exceptions as to which factors play in the public interest part of the analysis.
If we descend to the facts of this case, this may be an important point because one of the themes, strong themes, it appears running through the upper tribunal's decision, was that this was a young man who knew that his status was precarious. His brothers and his parents had been granted LTR, but he nevertheless persisted. Scenario B might have come to a different decision if he had in fact strong settled status, but nevertheless got into trouble. And on your analysis, the upper tribunal wouldn't have been not allowed to engage in an analysis on either basis.
it would be constrained by the operation of the exception with regard to its facility to attribute adverse weight to his precarious status. It would not be constrained by the structure of Part 5A from considering the application of additional weight on the very compelling side of the equation with regard to his acquisition of settlement. That's the submission. And we do say that there are tangible benefits from the adoption of this approach. And they are benefits which we detail in paragraph 32 of the speaking note, which are plainly more compatible with the objects of Parliament when implementing this statutory scheme than excluding or rejecting the argument.
Give us a summary of your best benefit.
So the primary benefit is consistency, because what one gets on this approach is the management of the exercise of discretion by the tribunal, which is guided by the express terms of the statute, which is in the context of those fitting within the exceptions, section 117C4, you do not need to revisit issues of precariousness in your subsequent very compelling circumstance assessment. And why is that beneficial? Well, in this particular case, what did the tribunal have to do? We turn up to the tribunal's decision. It had to fudge issues of private and family life in its ultimate evaluation. If you turn to the core bundle for a moment,
when you say fudge, you mean
blur.
later.
Blur
there are many circumstances, surely, where family life and private life intermingle.
Absolutely right. I mean, this is, again, one of the problems with this statutory scheme, is that it obliges decision makers to carve up Article 8 life into different elements, whereas in reality, the two are frequently aligned and amalgamated. It's a very difficult exercise for a court to have to perform. And that's another reason why, to the extent it's feasible, by operating this statutory scheme, one should not have to perform it. And this is one of the instances where one should not have to perform it. The relevant part of the decision is at page 39 of the core bundle, paragraph 51.
Can you just give us the paragraph numbers, because we've got it separate? Paragraph
51.
This is the hybrid reference, and it blurs. But what's your point?
My point, Lord, is this, that what the tribunal did was inconsistent with the proper operation of the statutory scheme. Because what we have on authority is that when one is looking at section 117B5, one is focusing exclusively on private life considerations. And one does not factor in family life considerations. And that position was confirmed by the Supreme Court in Rupiah. The relevant passage is paragraph 37 on page 94, tab 4.
How does this work if one goes back to 117B4? Little weight be given to private life, etc., if it's been established and here unlawfully.
The
similar wording to 1117B5. So how does this? It's got to work for both.
That is correct, my Lord. And it would work for both, because 117B4 wouldn't operate in this instance because we are lawful. And we can only bring ourselves within 117C4 because we're lawful. So that doesn't create any conflict with the submission.
There may be a situation where you have a private life, you were here unlawfully for 2 or 3 years, and then you were here lawfully. And all it's saying is that the initial little weight should be given to it. But it's very similar wording. On your analysis, it's out of account.
Well, 117B4 is out of the account in this instance because it is essentially replicated in 117C4A.
Well, no, it's 117C4A is simply you have to be lawfully resident here for most of your life. What B4 is talking about is about private life and relationships. You just give a little weight to when you weren't lawfully. It's still a factor. You just give a little weight to it. I'm struggling to understand how your analysis, which must surely apply identically, so you simply ignore it altogether,
Well, Lord,
even though there may be a little bit of weight to be given to it.
we say that the proposition I'm making to the court is that is one confined to serious offenders who fit within 117C4 and does not extend beyond that. I'm not making a more general submission that one excludes questions of lawfulness in other contexts for other serious offenders or for other medium offenders that don't fit the exceptions. It is confined to that. And consequently, my Lord, there is no incompatibility. 117B4 does not operate if you are fall to be included within that specific exception. There is an additional aspect to the deportee exception, which requires half your life to have been lawful. But the consequence is not any different. So 117B4 is automatically excluded. And
Forgive me, it's entirely my fault. I'm struggling to understand how you exclude 117B4 and 5 entirely. One reading of them is that there's simply a calibration by Parliament. So when you're looking at all these factors, if you're here unlawfully, then your private life relationships formed then are given little weight. Some weight, not no weight, but little weight. Equally, if you've established it when you're here precariously, it's little weight. And so when one comes to look at the exceptions, you look at through the prism of 117B, 4 and 5, when making these considerations. And therefore, what is baked in is, yes, you may have been here lawfully, you may have relationships, but quite a lot of it's been precarious. And some of the relationships may have been formed when you were here unlawfully. So when you come then to the final stage under 6, you've got, in a sense, you've got the matrix there, that it's lawful but precarious, the relationships, but so you have a fully coloured picture when you then come to consider the very compelling circumstances. So it's baked in, but it's the full picture.
But as a matter of fact, for medium offenders where the exceptions operate, 117B4 doesn't apply at all.
But that medium,
neither does 117.5. And
medium are a different. Medium have been dealt with. Parliament has decided to deal with serious offenders differently. You say not so differently.
Well,
is that
it's
what it comes down to?
It's the courts that have identified what Parliament apparently intended. And all I'm saying is that this is another instance in which this court should be, again, exploring what it is that Parliament intended. And consequent to that exploration, disapplying the general rule with regard to serious offenders who fall within the exceptions. And it is broadly speaking compatible with how these statutory provisions have been interpreted. And there is no public interest disbenefit from doing it. It simplifies the exercise that has to be performed by the ultimate decision maker. It avoids the risk that eventuated here before the First Tier Tribunal where we have a decision that the family exceptions, both of them, are operative in this case, so that there are unduly harsh consequences both for the appellant's wife and for his child. Those interests being subjugated to a general question of precariousness.
Speaking for myself, I'm not sure that is a fair analysis of what the upper tribunal did. But what I'm struggling with is the sense that even though somebody may have been here lawfully, but knowing, and this is the upper tribunal rationale, that whereas the rest of their family had been given status because of the appellant's behaviour and criminal conduct, they were not, but the appellant, in this case, persisted in criminal conduct. You say that that is not something that could lawfully be taken into account. That's what it comes down to. That is completely out of the picture.
It is out of the picture.
I find that very difficult, speaking for myself, as a matter of analysis, let alone a matter of merits, let alone of the intention of Parliament, because it's quite a dramatic proposition.
Except that
particularly in the context of this case, and I can understand why you make it.
It is a dramatic proposition, but it is guided by what Parliament has done in respect of these exceptions. And I appreciate that we are going round, and I've made my submission.
We're going down rabbit holes, I think, but one of the things, Mr. Jones, you may want to address specifically is that on your analysis, those of medium or serious criminality in terms of convictions would be better off than someone who has no conviction at all.
Let me think on that for a moment.
Well, why else have 117B 4 and 5?
But my lady, only in the very, very rigid and strict circumstances where 117C4 operates. And that is, is an extraordinarily specific set of circumstances.
Yes, but why should they benefit?
Well,
whereas an unlawful resident or one who has had precarious residence should not benefit from exceptions 1 and 2, on the basis that you're saying that exceptions 1 and 2 thereby vitiate effectively the impact of 117B 4 and 5.
I think the answer to that really must be that if I were representing an individual,
I'm not. That's why we're going to come back in due course, as soon as we may, to the actual facts before us, because my lord's right. I mean, whichever way the cookie crumbles in terms of our determination and analysis, the one thing that is certain is that, unfortunately, the appellant is not a medium serious.
We wouldn't be him, if that were the case. But
I doubt it, but
I think if
we need to move on.
Well, if I may just answer that question and then happily move on.
Yeah.
The answer is that individual that you've named, a person with no criminal offending, would not be prejudiced as against a deportee. Because the simple answer would be, how can one implement a scheme which prejudices such persons with comparable characteristics of long residence through childhood, with fixed ties of the quality described in section 117C4. How can one prejudice them as against a person with substantial public interest considerations informing their expulsion? And the answer is you couldn't possibly in a proportionality assessment do that. So one is actually assisted by what is framed in 117C. But because what Parliament is saying is you can only do this to deportees, take this action in deportees with these characteristics in these circumstances. You're dealing with a person who has no criminal offences with similar circumstances, be plainly disproportionate to subject that individual to an expulsion exercise, where they are effectively have all of the characteristics of a Maslov applicant, but none of the negative public interest considerations that operate alongside it. So I think that would be my answer to that.
Thank you.
And now I will move on. And I am grateful for the court's interaction. I hope I've responded to the questions, possibly imperfectly, but you have our submission. If I could just take you then to position 2, which is on page 6 of the speaking note. This is our alternative position as to how the tribunal should have approached the consequences of inclusion of the appellant within section 117C for the purposes of evaluating the rupiah exception. I can take you to paragraph 49 of rupiah if it would assist, but I think this court is doubtless familiar with it. And so the exception operates in circumstances where there are particularly strong features of a private life. What we say is that, based first of all on the fact that the Secretary of State herself acknowledged that the social and cultural integration element of section 117C4 was met, that was a compelling indicator that the threshold specified in rupiah was met. So we draw a parallel between that 117C4B threshold and the particular features of the strong features of private life. And we fixed that submission principally in the guidance that's been afforded by this court in the case of CI Nigeria, which appears in the authorities bundle.
Can you just repeat what the proposition is that you're contending for?
So the proposition is essentially that in instances where the section 117C4B requirement is met, that a person is socially and culturally integrated into the United Kingdom, that satisfaction of that condition crosses the threshold for private life with particularly strong features as described in rupiah.
Without more?
Yes.
Without any further consideration at all?
Well, the consideration has been performed in this instance by the Secretary of State at first instance, accepting the satisfaction of that threshold.
Well,
and it is a threshold, milady, which, described in CI, as I'll take you to now, it obliges a comprehensive evaluation of all of the material aspects of private life, not confined to or constrained by the language of the statute with regard to culture and social, but everything. If I could just take you to CI Nigeria.
And when you do, can you also help us with how then 117C6 fits in, of the requirement to show very compelling circumstances?
Of course, Lord. If we could just briefly then look at CI Nigeria to begin with, which is at tab 16 of the authorities bundle. And the first reference I can take the court to is at page 392 of the authorities bundle, paragraph 78, which just makes the point that I was making a moment ago about the scope of an evaluation of social and cultural integration for the purpose of 117C4. And it's the second half of that paragraph 78 begins the phrase socially and culturally integrated in the UK as a composite one used to denote a totality of human relationships and aspects of social identity which are protected by the right to respect for private life. While criminal offending may be a result of a cause or lack of breakdown of ties, family, friends, and the wider community, but it has led to that or contributed to a state of affairs, and the offender is not socially or culturally integrated in the UK is a question of fact. So it's a composite question which encompasses all aspects of the individual's private life. And then if we step back for a moment to paragraph 57, which is at page 387. See that when evaluating this provision, the nature and formation of, under the heading nature and formation of private life, the court says this: in assessing whether a foreign criminal is socially and culturally integrated in the UK, it's important to keep in mind the rationale behind the test is to determine whether the person concerned has established a private life in the UK which has a substantial claim to protection under Article 8. So a comprehensive evaluation of all material considerations referable to Article 8, and then the identification of a substantial claim for protection under Article 8 in order to be included within that provision in the first instance. And all of that is, of course, framed within the context of an evaluation, which has already identified is one which where the exception is related to the Maslow criteria in the first place. So the application of an elevated form of protection to this particular category of individual. And we say one can readily derive from that guidance and understanding of what this exception is all about, that the root pure exception should be regarded as met in instances where 117C4B is satisfied. And, my Lord, to answer your Lordship's question about how that impacts on the 117C6 question, it impacts so as to cause 117B5 to be disapplied on an ordinary operation of the root pure exception, which is this is a private life with particularly strong features consequent to inclusion within the exception, and as a result, one does not then need to factor in precariousness again to that equation. Because it would be inconsistent with the statutory scheme and the guidance of root pure to be importing those considerations back in where Parliament has effectively construed the statutory scheme so as to exclude them for persons such as the appellant.
But it doesn't exclude them where you're within subsection 6.
I appreciate that
because subsection 6 is precisely dealing with a situation where exception 1 does not resolve the matter. And you have to then consider broader circumstances. And what it seems to me you're trying to do is to use an exception which isn't sufficient to exclude other things. I just don't see how logically it works.
What I'm endeavouring to do, my Lord, is to follow what the object of these statutory provisions is, which is to create a framework within which the evaluation of Article 8 interests is performed. Yes. And to better enable tribunals, and it would have enabled this tribunal, First Tier Tribunal, to dispose of this case more, certainly in a way that was more favourable to my client. But it would also have assisted the upper tribunal to dispose of this matter without so much of a blurring of issues which apparently were to be excluded from the private life exception. To have clarity in the sense that in instances, and it's a very straightforward submission, my Lord, and it is in fact quite narrowly drawn in terms of those to whom it would apply, where the exceptions within 117C operate, you are guided in your subsequent evaluation of section 117C6 by that fact. And that includes being guided with regard to the significance one applies to immigration status.
Can you just dictate that very simple submission to us again?
I'm not sure I'll be able to. I'll do my best. So our straightforward submission, my Lord, is this. In instances where a serious offender fits comprehensively within the exceptions specified in section...
In instances where a serious offender
fits within the specific exception with regard to private life in section 117C4.
Yes.
That guides subsequent evaluation of very compelling circumstances in 117C6 with regard to, in particular, to issues of status and strength of ties.
Forgive me, I think that's a little bit of manipulation and or sophistry, because 117C6 isn't dealing with a situation where somebody has met exception 1 or exception 2. It's dealing with a situation where meeting exception 1 or section 2 isn't good enough. And there is no concept here of having met exception 1 or exception 2. It's not a requirement that you should have met exception 1 or section 2, and it isn't enough. So it seems to me that but using those as building blocks is to stand on something that isn't there.
Well, Lord, we just come back to my submission, our submission, which is essentially that one should be looking at the operation of this scheme generally. And in doing so, one is afforded a more coherent framework against which the assessment of what is otherwise an extremely general exercise to be performed under 117C6 will otherwise operate. And where that provision is expressly directing decision makers to consider the operation of the preceding exceptions and look for something more, we say, even acknowledging the imperfections of these statutes, that what Parliament is aiming at is pushing an assessment which is made by reference to those exceptions, and that a decision should be framed within that context, including extending benefit as appropriate to the limited extent it's derivable from those exceptions to a serious offender, solely in this instance with regard to the immigration status they enjoy. That is the submission.
So shall we move on and look at the criticisms that you want to make about the actual judgment?
Yes. Safer territory for me, I suspect. If we could go to page 7 of the speaking note.
Yes.
So our final submission with regard to the error of law, the approach of the Upper Tribunal and the error of law hearing, is that, contrary to the conclusion that it recorded, there was no necessity to embark upon a further review of questions of precariousness and the existence of a particularly strong feature of the private life, because, in fact, the First Tier Tribunal had settled that issue within the body of the determination. And it is material to recall that the First Tier excluded section 117B5 on a flawed basis, understanding that the exception specified in Rupia was constrained by immigration status, that one had to be settled in order to get the benefit of that exception.
So wherever the Upper Tribunal say, as they do several times in various paragraphs, just within exception 1, just within exception 2, is their analysis. You say that doesn't matter.
Well,
because once you're there, you're in the foothills. So they weren't allowed to make that value judgment.
That's an evaluation that this court will have to perform when it looks at the reconsideration. At the moment, we're fixed on the error of law disposal.
But surely it feeds into that, because you say, if you're right, then once you're in exception 1 and 2, then the qualitative, how far you're in it, is irrelevant.
Well,
that's, as I understand, the logical consequence of your submission.
Well, we are very much focused at this stage, my Lord, on what the First Tier Tribunal did, and that obiter comment that the First Tier Tribunal made.
No, I'm focused on what the Upper Tribunal did in its analysis, and it concluded that they were just within exception 1.
I think it recorded that position with respect of exception 2, the family life exception. I'm not sure that it expressed that position. I suppose one would, if one broke down.
Paragraph 58, I think we do need to move on, Mr. Jones. Paragraph 58 of the Upper Tribunal decision, we are satisfied that notwithstanding the cumulative impact of the appellant meeting exceptions 1 and 2, together with all the other pros, the high threshold required by section 117C6 has not been met in this case. So, I mean, again, are you setting up straw men to knock them down? What the tribunal are doing, and my Lord's point is this, that section 117C6 is what is concerning the Upper Tribunal and is concerning us.
But, my Lord, my Lady, that is where the Upper Tribunal has one of the ways in which the Upper Tribunal has gone wrong at the reconsideration process in our submission is that it has ranged well beyond the scope of that exercise.
No, it hasn't, because you've accepted that this is serious offending.
Yes,
And so it definitely falls within 1176C6.
yes.
Of course it does. So there's got to be exception 1 and 2, compelling reasons over and above. So in paragraph 58, they're saying, we are satisfied that notwithstanding the cumulative impact of the appellant meeting exceptions 1 and 2, nevertheless, it doesn't come to the necessary standard, which is required by 117C6.
Milady, we will say that that was an impermissible assessment for them to undertake. And at this juncture of our submission, we are focused on the error of law.
Well, I think, yes, but
And
one of the kind of the basics that we started with right at the outset of the hearing this morning was you haven't established that the tribunal committed an impermissible error in determining that, having found that there was an error of law in the first tribunal's decision-making process, that they thereafter would assume responsibility for the decision-making purpose. Now, I understand that the second part of your appeal is that if we can't get over that, then we look at what they did. But I think we've now got surely into the second part of your appeal.
well, not quite, sadly.
Well, I'm afraid that looking at the time, we're not going to shut Mr. Malik out.
Absolutely not, Milady. And I'm very happy to rely on what's said in writing, but if I might just address...
Well, we are going round in circles a bit.
Well, I hope we're not, actually,
I
Milady.
think we are, actually.
Well, Lady, if we are looking at very compelling circumstances at the error of law stage, we should not be looking at the Upper Tribunal's disposal. We should be looking at what the First Tier Tribunal did. And what the First Tier Tribunal did is set out at paragraph 123.
Well, before you go there, Mr. Jones, you've already said that you don't want to take exception with the Upper Tribunal finding that the First Tier Tribunal made an error of law, and you took us to Schedule A, page 3, error of law, in conclusion, and they found, in accordance with your submissions, there were 2 errors of law. So we then open the gateway to what they do next.
But the gateway is dictated first by their identification of how those findings impacted on the ultimate disposal of the
And
appeal.
which authority do you cite in support of that principle?
Well, Lady, how the Upper Tribunal...
Well, you said that's a case management decision, isn't it?
It is, my lady.
Yes, so on that basis, you've got a bit of an uphill struggle, because that was a course open to them.
I understand that, my lady, but we're saying that the case management decisions are susceptible to review on the basis that they are unlawful or perverse.
Well, they are susceptible to review, of course they are, but you will be aware of the long list of authorities that say that case management decisions have got to be very erroneous for this court to interfere with them.
And this was a very erroneous decision, because we say simply this...
Well, you're saying it's a very erroneous outcome, but that doesn't necessarily mean that the case management decision was wrong.
It was wrong, and it was wrong, lady, because the...
Well, it wasn't your preferred outcome, but you have got to establish, and I can only speak for myself, of course, and it could be that I'm being very, very obtuse, but I can't see how you're getting any headway with what you're doing now, save in relation to the second part of your appeal.
Well, let me make this submission very briskly then, if I may, and then I will step on to the second stage.
Right.
And I am conscious of the time, and I don't want my own friend to be prejudiced. If one looks very quickly at the First Tier Tribunal decision, and I'm sure that this panel is very well familiar with it, page 123, and in particular paragraphs 140 to 142.
Let's get there first. So 123, 140 to 142.
it's probably just worth flagging up 139, the judge emphasising that he's found the exercise to be performed in very compelling circumstances assessment not a straightforward one. It's a very difficult case, lots of matters going either way. Then he says this, looking at first at E and Y, whereas the effect of deportation upon them must not be understated, the consequences I've described do not outweigh the very high public interest arising from 10 years prison sentence. They would be unduly harsh were the appellant a medium offender and might even reach the threshold of very compelling circumstances had he received a significantly shorter sentence. So something above 4 years but significantly under 10. But the consequences are not catastrophic. The effects on Y of separation from the appellant must be managed by E and her family, and they will be able to protect him from the very worst outcomes. The weight carried by the relationship with E is weakened by it having been formed when the appellant's immigration status was precarious. Put that to one side for a moment. 141, had those pros been taken in combination with the appellant's private life considerations, with the latter not being reduced by his lack of settled status. Remember, that reduction in settled status is the point at which the error of laws occur. I would have allowed the appeal. So he then goes on to talk about the actual real gravity of the case by reference to the private life considerations, the impact for the appellant of return to Zimbabwe. So the First Tier Tribunal is saying straightforwardly, I would have allowed the appeal but for the fact that this man does not have settled status.
Yes, that doesn't bind the upper tribunal though, does it?
But it doesn't bind them, lady, but when they're evaluating what they should do with the appeal, having identified the errors of law, it should affect the next step.
Why? Because this is one paragraph in the First Tier Tribunals, 144 was it, or longer?
143, I think.
Thank you. So it's one paragraph, and that's a part of a sentence within a very short paragraph. And why should that dictate the decision of the upper tribunal as to what it's going to do, whether to remit it or to retain it?
First of all, my lady, if one just steps back for a moment to page 118, which is the First Tier Tribunal decision where he is looking at the weight to be given to relative aspects of the private life and family life. The two factors...
You're not answering my question, Mr. Jones.
I hope I will in a roundabout way.
Well, I'd like you to answer it directly first, and then you can give me an explanation for it. Why is it, in accordance with the statutory provisions and the rules, and Mr. Malik sets them out in his skeleton argument, why is it that that particular part of the sentence in paragraph 141 should bind the upper tribunal's hands as to how they should dispose of the appeal?
For the very reasons that my friend advocates the substance and reliability of the upper tribunal's disposal, those very reasons inform why they should not have interfered with, or should have recognised the inevitable consequences of their particular errors of law that they identified. But this First Tier Tribunal, the A.H. Sudan...
But that's not provided for statutorily. It gives them a binary option. You either remit or you retain, and there is no guidance on which they should do. It's a matter of their discretion. So are you saying that it's totally irrational, what they've done?
It's a high threshold.
Or unreasonable?
It is unreasonable.
It is. So, I mean, it's got to be Wednesbury unreasonable, not just unreasonable because it doesn't fit in with your preference.
But lady, the answer is this. The two elements of error which the upper tribunal identified in the decision were both elements which went to decrease the weight given to the appellant's private life. You can find that at paragraph 112 of the First Tier Tribunal's decision. The fact that he wasn't settled meant that they disapplied the Maslow principle. The fact that he wasn't settled meant that he could not avail himself of the exception of the exceptional criteria specified in Rupia. So two negatives. You remove both of those negatives by identifying that they are flawed in law, as the upper tribunal did. If one removes those two negatives, we say that with the exception, the possible exception of the necessity to evaluate whether in fact there was a particularly strong private life, there is no further exercise to be performed by the upper tribunal.
But it doesn't end there. Mr. Jones does it, taking up my lady's point. if you turn to paragraph 57 of the upper tribunal's error of law decision, they say in terms, we're satisfied that the FTT's error of law in its approach to Maslov and section 11755 has infected its obiter conclusion in 141.
But my Lord,
Now, how can one say that it's unreasonable? That was the part of the reason that they decided to make a case management decision.
and indeed I was going to take you to that, my Lord, because how has it infected it? How is the upper tribunal identifying that the Maslov principle has infected the very compelling circumstance assessment? It doesn't. And in fact, the only way in which that error could impact on the very compelling circumstance assessment is positively.
You say that, but there are circumstances in which, if there is a particular legal door that you think is shut, it may well then infect the way in which you analyse other aspects of the case and the facts, because you know that ultimately it's not going to make any difference. So that no doubt was part of the consideration.
But my Lord, it's not articulated. And with respect, I cannot see, and it's certainly not identified, a way in which introducing the Maslov principle into a very finely balanced exercise of very compelling circumstances could impact other than affirmatively. What the Maslov principle obligates is the requirement. This is a paragraph, it's in tab 3 of the authorities bundle.
I think you're going off course again, Mr. Jones, with respect. The very narrow point I'd like you to address, and my lords are asking you to address, I think, and they'll tell me if I'm wrong, is how are you putting this case? Are you saying it's irrational? Are you saying it's unreasonable that they took the decision, which was open to them, to retain the decision and remake it?
Yes.
Yes. Now, you've said that that is on the basis of them accepting that the First Tier Tribunal, apart from 2 instances, was on the right lines. But my Lord, Lord Justice Haddon-Cave then says, and I don't think you've really met it yet, yes, but if you look at paragraph 57, they're saying it's infected the whole process. Now, that was their decision.
But that is the irrationality, my lady. Because how is it infected?
Because in the exercise of their discretion, looking at, and I'm positing this in response to, I shouldn't be answering the questions usually, but I mean, because in relation to their assessment of all of the findings, if the First Tier Tribunal hadn't gone wrong in the 2 instances that it did, it would have had a different perspective upon which to view the other issues. It was a throwaway line, in other words.
Lady, the only way that the Maslov principle could operate, the introduction of it, was positively. The First Tier Tribunal specifically identified the inability to apply that principle as a factor which was negative to its disposal. So in its final balancing, those last few paragraphs that we looked at, paragraphs 140 to 142, it has factored into that fine balance, that marginal decision against the appellant, that the Maslov principle, which says that particularly serious reasons have to be afforded for enforcing the removal of a person such as the appellant who has long lawful residence, established as a child, who is socially and culturally integrated, that principle doesn't operate. So if one introduces that principle, acknowledging that it was wrong to exclude it, in what way can the introduction of that positive principle impact adversely on the assessment to be performed?
Well,
it
in
can
many,
only go in one
instances,
direction.
it depends, because you're talking about a range of decisions here, and it doesn't matter that this court may have reached a different decision. You've got to establish that the upper tribunal was outside the band of reasonableness. That's Wednesbury unreasonable. And I do think, if I may say so, Mr. Jones, that you shouldn't ignore, as it were, perhaps the ground you've got to cover under the second aspect of your appeal.
Well, lady, again, you have my submission on that point.
We
and
do,
indeed I've
and we
articulated
have
it.
your speaking note.
It is the relevant part is from paragraph.
As I say, Ms Jones, I speak for myself. My lords may have different views that they want to explore with you on that, but we do have to keep an eye on the time because it's now 12:15.
And I have dealt with this, our position with regard to the irrationality of the upper tribunal's disposal in this regard from paragraphs 39 through to 55 of the speaking note.
Yes.
And what we do there is revisit the specifics of the First Tier Tribunal's disposal and identify the actual implications of introducing, for instance, the Maslow principle into the assessment, which, as I have submitted, this is a paragraph 40 to 42 of the speaking note, is only capable of impacting affirmatively. And that is, and so the irrationality is that the upper tribunal has not engaged effectively with the legal consequences of the recognition that Maslow principle operates in this case. And further, it has recorded irrational conclusions as to the quality of the findings secured by the First Tier Tribunal with regard to issues of private life, inferring that there was no conclusion recorded which was capable of crossing the particularly strong features of private life threshold for Rupia. Because in fact, when one evaluates the particulars of the First Tier Tribunal's findings and interrogates them carefully, as I have done in the speaking note, that threshold is amply crossed by the particular findings that the First Tier actually recorded. And recognising then that the upper tribunal should interfere with the decision of an expert tribunal, which is what this First Tier Tribunal was, a trial tribunal which heard a day and a half of evidence and extensive submissions across the whole range of issues material to the very compelling circumstances.
You're still on the same point then, Mr Jones.
I'm just about to finish.
Yeah, because we have got your
The decision was irrational. And now we'll move on very briefly to step 2, page 10 of the speaking note.
Yep.
So it's paragraph 59 onwards, page 10.
And again, I think I can deal with this fairly briefly because the court is clearly familiar with the findings recorded by the upper tribunal in the error of law hearing as to why it decided reconsideration was necessary. And it specifies its position in that issue in the very section, I think, lady, that you referred us to a moment ago, from paragraph 56 of the upper tribunal decision, page 20 of the determination.
Thank you.
And part of it was to grapple with the way in which the Maslow error infected the decision below. But part of it, principally, the concern was to look again at the evidence going to the existence of a particularly strong private life. The tribunal emphasising or expressing the apprehension that employment and community ties were not adequately evidenced or ruled upon. And you'll find that in particular paragraph 57. And I have in paragraph 60 of the speaking note, page 11, outlined what we say were the parameters then of the reconsideration session as expressed and described by the upper tribunal in the error of law.
Something seems to have gone wrong with paragraph 59. It's incomplete. Could you just complete it for us? The upper tribunal erred first at the reconsid.
At the reconsideration stage, I think we could just include it there.
Yeah.
I hope there's nothing else missed, but I'm sure there's quite enough left to keep the court occupied. So, very briefly, we say the factual findings, to the extent factual findings were regarded as deficient, we've set this out in the Schedule A. It was confined to the proposition that you'll find this on page 2 of Schedule A, deficiencies in findings of fact. It all focuses on what the upper tribunal identifies as the failure to make a particular finding that there were particular strong features of private life. And in terms of the reassessment to be performed, as the court has identified, in part it was to review the impact of the error on Maslow as well, and explain what we say the impact of that is. And it is relevant to note that the Upper Tribunal does identify ultimately that the fact of the appellants being a young person with long residence from childhood is a matter that does impact significantly in the assessment. And you find that in the Upper Tribunal's reconsideration decision. I think it's at paragraph 53 on page 40. Maybe mistaken about that. Oh, sorry, I beg your pardon. It's paragraph 57, page 41. So they emphasise in the concluding sentence of that paragraph the special situation the appellant is in by virtue of having been in the UK lawfully for most of his life since his childhood. So that factor is factored in an affirmative way into the ultimate assessment performed by the Upper Tribunal. So limited areas to be evaluated with regard to fact and with regard to law. And in terms of the updating of evidence, to further confirm the narrowness of the review that the Upper Tribunal was describing its intention to perform, all of the evidence it sought, or indeed indicated would be admitted, related to updating evidence. And the language of that is clear both from the directions in the error of law hearing and from paragraph 59 of that determination. And all of the findings of the First Tier Tribunal, bar the ones that were fixed on error of law, which was very narrow, were to be retained, unadulterated. And no error of law was contended for by the respondent in respect of any of those other findings, nor identified by the Upper Tribunal. So the appellant prepared the appeal before the Upper Tribunal for the reconsideration hearing on that very narrow basis, that what the Upper Tribunal was concerned with was the adduction of further evidence and submissions about the issue of whether there were particularly strong features of private life and the impact of the mass loss provision. And that was the way that the case was prepared is amply apparent from the terms of the skeleton argument prepared by the appellants for the Upper Tribunal reconsideration, which appears in the supplementary bundle of page 135.
Can you just take me to the directions before we go there?
Of course.
As to the evidence to be sought and the determination that the findings of the First Tier Tribunal would be preserved, because I'm rather concerned that you are interpreting what they said to mean that they conceded that they would continue unadulterated.
Well,
because I don't know that any tribunal could sensibly tie its own hands in that way if the fresh evidence undermined those findings. It wouldn't be remaking a decision at all. It would be shackled, and I don't think that this court would, certainly speaking for myself, I don't think that I would support such a
and I wouldn't make that
statement of
submission
principle.
to your ladyship either.
It's just that you use the word unadulterated.
Well, at that point, when the reconsideration decision is being, when the error of law decision is being made, there is no impact to be identified with respect to the findings of the First Tier Tribunal.
No, that's why I want you to take me to the directions, because if you're saying we proceeded on the basis of an explicit direction, and we've been therefore deprived due process, that's one thing. But if it's just your interpretation, that's why I say I was just struck by your submission that they've got to remain unadulterated.
Well, one is guided not only by the directions, but also by what is said in the body of the remaking of the decision elements. And what you see there at paragraph 57 is the emphasis we've already seen on the need to make findings about the presence of particularly strong features of the private life, particularly at the last 3 lines on page 92, paragraph 57. The court identifying, the upper tribunal identifying issues of employment and community ties as being, in its estimation, inadequately evaluated. And what you have too is that at paragraph 59, both representatives making clear, that's the respondent and the appellant, that they were content to rely solely on the findings of fact and factual evaluations that were performed by the First Tier Tribunal. So not just the findings of fact, but the evaluations of those facts by the First Tier.
Yes, but the upper tribunal made it clear in paragraph 57 that they thought that the FTT had since backloaded the analysis and looked at the Zimbabwe end of the equation, but hadn't sufficiently analysed the front end of it, and also looked at the broader picture. And that's effectively what they say in 57.
What they're actually saying, my Lord, in 57, in that respect, and I completely acknowledge your Lordship is right about that, ties in still to the question of particularly strong features of private life. Because the observations they're making there are essentially, again, in response to the submission I made before them, that issue should have been treated as resolved. Because if one reads 57, whilst the FTT has highlighted features of the appellant's private life in the UK that might be capable of being viewed as particularly strong, when assessed holistically, there's been no clear finding to this effect. We acknowledge the FTT found exception 1 to be met by a considerable margin. However, the FTT focused on the attention on the third element, exception 1, relevant to the appellant's circumstances in Zimbabwe. That's absolutely correct, my Lord. But the first element of that sentence is again reiterating what is the overarching theme of this guidance for the rehearing, which is we need to revisit the evidence going to the presence of particularly strong private life. There's no suggestion.
What it goes on to say, that paragraph, is we've already made it clear that 117b5 is directed at the former only. If the FTT directed itself to the authorities on the approach to private life, it cannot be said that it would have inevitably concluded the appeal in the appellant's favour. There are clearly obvious factors in support of the appellant having a particularly strong private life, but these must be viewed in context.
Yes, maybe. And again, that comes back to that very same question. That in their estimation, whether or not there were particularly strong features of private life had not been resolved. And it was, in their estimation, something that was capable of going either way. But it still focuses.
But it's talking about a context. That's my Lord's point, I think.
Well,
why should we undermine the express meaning of the word, the explicit meaning of the word?
But with respect, my lady, the express terms of this paragraph as a whole, and indeed what the tribunal subsequently indicate they intend to do,
Right.
is all directed at one point, essentially, which is the correction, the factual evaluation of matters going to the 2 legal errors that were identified.
Speaking for myself, I don't read 57 to 63 like that. But going back to my lady's point, your submission appears to be that the upper tribunal in the first judgment was shackling itself or narrowing the scope of its remaking of the decision.
And indeed, that's precisely what it should have done. It was conducting at that point.
Even though it was a different constitution. It's a very surprising thing for a tribunal to have done.
Not in a circumstance, my lord, when the errors are so narrowly confined, and where no other element of this determination of the first tier is impugned by the respondent at all, and to the extent that we offered criticism of it, those criticisms were not upheld.
I think we've got your submission, but as my lady said, the word context in the last line of page 92 seems to be a broader prism than the one that you would accept.
Well, I think it's important, my lord, as well, to recognise the way in which the authority directs that the upper tribunal should operate in circumstances like this. And indeed, we make reference explicitly within our skeleton to the case of LS Uzbekistan, which incorporates guidance from the preceding decision of this court in DK Serbia. And if I could just take you briefly to that LS Uzbekistan at tab 22, and in particular page 520, paragraph 16.
Sorry, could you give me the paragraph number?
Of course, lady. It's paragraph 16 of
16.
LS Uzbekistan.
Thank you.
And with the court's permission, if I just briskly go through the authorities to which the court is referring and then highlight the conclusion. If you look at paragraph 16, it's page 519. The first case that's referenced by the tribunal, this is an instance, again, where there's complaint about the interference by the upper tribunal with what were contended to be retained findings of fact by the first tier tribunal. Not upheld in this case because ultimately it was concluded that the retained findings were marred by the fact that a concession the sceptre state had made had been withdrawn. So the first case referred to is the case of Macur, and the relevant part, if we just look at the second indented paragraph at 44, Lord Justice Sedley saying the reasons why it's important to be rigorous about the context in which one revisits preceding findings of fact about this is that reopening a concluded decision by definition deprives a party of a favourable judgment and renders uncertain something which was certain. If a discrete element of the first determination is faulty, it is that alone which needs to be reconsidered. It seems to me wrong in principle for an entire edifice of reasoning to be dismantled if the defect in it can be remedied by limited intervention, and correspondingly right in principle for the AIT to be cautious and explicit about what it remits for redetermination. In this instance, no remission, the matter is retained. But, as I've already said, very narrow issues, a very narrow edifice to be engaged with regard to the flaws in the first tier determination. We step on then to DK Serbia, which is referred to.
Mr. Jones, sorry to interrupt, but the principle in paragraph 19, which is the summary of it, is very well known, and courts won't reopen unless the findings below are undermined by an error of law, which is what the upper tribunal found here. Two errors of law and gaps in the analysis.
2 errors of law and a single gap in the analysis which was referable to the first error of law, the particular strong features of a private law. Apart from that, no deficiencies. And I was coming on to 19, but it's quite important to, and I'll leave it to the panel to familiarise themselves with the remaining aspects of the judgment if that's your preference. But what pervades, in particular from the decision in HF Algeria, is the importance of finality in decision making, the importance of the retention of retained findings of fact. And whilst it is acknowledged that it is permissible for another tribunal to intervene and review those findings of fact, which is identified by your lordship by reference to paragraph 19, the court in LS Uzbekistan is very particular as to when that's appropriate, either in the presence of new material or in exceptional other circumstances. But there are no exceptional other circumstances for the upper tribunal to be revisiting this evaluation comprehensively, which is what
I think you've just answered your own point there, Mr. Jones, with respect, because it's not findings of fact, it's the evaluation of the facts as found by reason of the new information that we're talking about here. That's what the upper tribunal is saying, surely. They're not saying, now we've seen the new material, we think that the findings of fact were wrong, because that's not what they're about. They're remaking the decision. And they're saying, now that we've seen the new material, and we bear in mind what went wrong in the court below, what wasn't put into the melting pot, as it were, we now put a different, we reach a different balance. It's the evaluation. They're not altering findings of fact, are they, the upper tribunal here?
Well,
they're saying that there are these additional factors that now just give it a completely different atmosphere, I suppose. But that's the difference.
But Melody, at this stage, what we're concerned with is what it was that the tribunal conveyed, and the panel may not agree with me, but what it conveyed it was intending to do. Now, it may be that this, and certainly from the upper tribunal's ultimate reconsideration, it is describing its intent exactly in the context of what this panel is identifying, that clearly it's going to perform a comprehensive reappraisal of all of the issues in the context of
I don't think we've said that. Mr.
Well, I
Jones.
apologise, but that's what the upper tribunal says it's going to do, and that's what it does.
I don't know if they do, but all right, we'll note what you say about it, but I don't think that's what they do say.
The line that my lady referred you to, 4 lines up from the bottom of page 92, it surely flags up this issue that the upper tribunal said it cannot be said that the FT would have inevitably concluded the appeal in the appellant's favour if they'd approached the matter correctly. So it was flagging up surely there, as my lady pointed out, that this was going to be a review, but not in the entirely narrow terms that you suggest.
I think it was more of an answer, certainly the way that we read it, a reference to our earlier submission, that there was only one outcome possible from the rectification or the recognition of the errors of law that had been perpetrated by the First Tier. And inevitably the tribunal is going to have to express itself in that way, having decided that it's going to reconsider those specific questions.
It doesn't, with respect. My Lord's right, surely, that part of that paragraph makes it clear to you, and I think your answer recognises that they were saying, we don't agree with you, Mr. Jones, it's not inevitable. That's exactly what that sentence says. It is not inevitable.
It is not inevitable that the adduction of further evidence on the specific issues that we've identified as there being insufficient findings will result in a different outcome. I accept that. That is what they're saying. What they're not saying is it's not inevitable when we perform a review of all of the issues in this case, referable to the facts recorded by the First Tier, and indeed reformulate the conclusions of the First Tier to a material extent, that we couldn't come to a different conclusion.
All right, well,
Lady, at this point, all we're concerned with really is a procedural point, which is what the appellant understood the upper tribunal was intending to do.
Well, it's a good point to make if you've got the basis for making the point, and we've taken you to the judgment, which seems to suggest that you've not got a lot of legs on the suggestion that you were misled. Well, unintentionally, but misled into what you.
And I wouldn't for a moment suggest the upper tribunal was acting anywhere in kind of.
You did say that, but if you're suggesting, as you did, that the basis of the decision, the errors of law, was such that you prepared the appeal on a certain basis and were then, as it were, taken by surprise, I don't think that part of the judgment assists you.
Well, Lady, again, you have our submission. And
yes,
you might be assisted by looking at the skeleton argument and the scope of the evidence that was adduced by the appellant.
Well, we look at the judgment, because the judgment of the upper tribunal didn't accord with all of your submissions. Accorded with some of them, but not all of them. So we look at the judgment and we look to see whether or not there's an ambiguity in that. And well, you've heard what we've got to say about that. Yes. So let's move on.
I'm content. I'm grateful for the court's attention on these issues. Again, I do commend to you the remaining observations we recorded in the speaking note with regard to the conduct of the reconsideration.
Yes.
Now, if we could step on then to conduct of the reconsideration exercises, paragraph or page 11 of the speaking note. We can get through this fairly briefly because it covers the same territory that we've been touching upon. It is our submission, and we commend the written argument to you that the tribunal did progress beyond that which the appellant understood the sphere of that reconsideration to be.
Okay.
Now, I have at paragraph 14, page 14 rather, of the speaking notes, paragraph 76 dealt with the issue of Malone and Friends' submission with regard to the status of expert tribunals and made some comments there, which again, I don't need to verbalise, I put them before you, but we make the simple point that the AH Sudan reference with which this court is doubtless familiar from Baroness Hale with regard to the treatment of expert tribunal decisions is equally applicable to the treatment of the first tier tribunal's decision as it is to the upper tribunals, particularly in an instance where what the tribunals here are predominantly concerned with are factual findings, save for the complexities that may surround the interpretation of 117B and C. And on that basis, we say that as I'll seek to demonstrate, when the tribunal went on to revisit matters which we say were settled by the first tier, it proceeded in a manner which was unlawful.
I don't think Baroness Hale had in mind where the tribunal below misled itself on the law.
And again, we come back, my Lord, just to that very simple point that the aspects in which those errors are perpetrated.
We've got your submission.
You have it. So I think then you'll be relieved to hear we're finally at step 3 and the reconsideration decision itself. Now, in respect of that decision, we say there are 3 principal ways in which the upper tribunal erred, and that they impacted upon each of the critical aspects of its disposal. First, this is page 15 of the speaking note, paragraph 81. First, on the reassessment of public interest, then on the re-evaluation of private life interests, and finally on the assessment of family life. And that each of the errors that it perpetrated were material, and each of them, either individually and certainly in combination, suffice to establish that the reconsideration decision is flawed. And perhaps the best way to deal with this is if I just give you the head notes. Over the lunch and adjournment, perhaps the court can want to interfere with your lunch, but consider the broader submissions in writing, and if there are any issues that arise from that, I could
Well, we have considered your skeleton argument, and as you know, we've not been shy about seeking your assistance.
Well, let me give you the head notes. Then.
Yes, do.
And again, you can.
But please don't understand that if we don't come back with any questions that were necessarily in favour of your
I wouldn't
arguments.
assume that for a moment, milady, but I'm grateful for the confirmation. With regard to the public interest, we say there are two points at which the upper tribunal fell into error. The first is in its treatment of the question of rehabilitation, and the second is with regard to its balancing of the question of the implications of the operation of the Maslow principle, and that was in particular with regard to its treatment of the Akinyemi decision of this court. Dealing with the rehabilitation issue first, page 15. In Schedule B that we've handed up, again to assist the court, we've set out at page 12 onward the findings of the First Tier Tribunal and the Upper Tribunal alongside each other on the issue of rehabilitation. And it's not necessary for the court to necessarily delve into those in detail now. Suffice to say, from the appellant's perspective, that what was identified by the First Tier, and this is outlined at paragraphs 84 through to 90 of the speaking note, was an exceptional exercise of rehabilitation in this case. That's the language of the First Tier. An exceptional exercise of rehabilitation which caused the First Tier to define the appellant as somebody who was a model of rehabilitation. You find that reference in paragraph 87 of the speaking note. The evidence of that rehabilitation was overwhelming. And the consequence of that evaluation was that despite the OASIS report that was put forward by the probation service defining the appellant as a medium offender, the First Tier Tribunal, after a comprehensive analysis of all the evidence, including a comprehensive evaluation of the appellant's testimony, concluded that he was very much at the bottom end of that scale of medium offenders. And you'll find that reference, paragraph 89 of the speaking notes, and the reference to the FTTJ's decision is there. A provides as low a risk of reoffending as someone in his position realistically could. And what the First Tier Tribunal also identified was his fixing as a medium offender by the probation service in their OASIS report was
medium risk.
Medium risk,
not medium offender.
I beg your pardon. Get muddled up with the deportation category. So a medium risk. the probation service fixing on that categorisation was a consequence purely of static factors. Static factors related to the offence that led to incarceration. That is the language that the First Tier Tribunal uses.
Yeah, I think certainly two of the Constitution have got familiarity.
And I'm very well aware
Yes.
of that. I've done my homework. And so I don't need to labour the point. But what is important is, and we provided the OASIS report, and I apologise it wasn't in the supplementary bundle, but it is in the additional documents in the shared link. When one looks at the OASIS report, what one discerns immediately, as the First Tier Tribunal judge did, was that there had been no actual engagement by the probation service when formulating that report with the appellant, or indeed with anybody in the prison. Because what they describe in the OASIS report is, we've attempted to make contact with the prison and failed to do so. So that 2017 report is prepared without any appreciation of the steps that the appellant has taken to rehabilitate himself in prison. It is also a report which is 2 years out of date by the time the matter goes before the First Tier Tribunal. So on a comprehensive considered evaluation by the judge, he arrives at his own conclusion as to the risk of reoffending and arrives at his own conclusion as to the quality of rehabilitation, which he ultimately ascribes some weight in the very compelling circumstance assessment he performs at the conclusion. Now,
2 points, Mr. Jones. Very quickly. Firstly, the upper tribunal had further evidence before them. They had the appellant was able to give evidence and so on. So there was that opportunity. Secondly, we've done our homework too. In paragraph 29 of the upper tribunal's second decision, cites Lord Justice Hamblin in Bimbuga and the fact that the questions of risk of reoffending in the great scale of things is not a major factor, to put it neutrally. So where does this really take you?
it takes us actually on to a further decision of this court after the decision in Bimbuga was handed down, which is the decision of CI Nigeria, in which the observations recorded in Bimbuga were not endorsed. If I could take you to tab 16 of the authorities bundle.
This is Lord Justice Underhill, is it?
I think that's right, my lord. Malay, apologies.
Did you say tab 16?
Tab 16, CI Nigeria.
Yeah. Sorry, it's not Lord Justice Underhill then. And which paragraph?
I'll just take you to it, maybe one moment. Apologise.
Paragraph 60 onwards, relevance of offending and imprisonment, which refers to Bimbuga.
Yes, mate, I think that's right. I do apologise. I've completely misdirected the court. It's not Bimbuga, CI at all. It's a case of HA. I beg your pardon. HA Iraq, tab 14.
And this is Lord Justice Underhill.
That's Underhill.
Your ladyship was obviously in the right direction. I was misdirecting you. I apologise for that. And the relevant part of that decision is, I think it's paragraph 141 and 142, which is pages 349 of the bundle. Does the court have it?
Yes, indeed.
It varies from case to case.
And
Yes.
rarely be of great weight.
If I could just take you to...
I think we've also got to note that B, paragraph B, in at page 1374, tribunals will properly be cautious about their ability to make findings on the risk of reoffending, and will usually be unable to do so with any confidence based on no more than the undertaking of prison courses or mere assertions of reform by the offender, or the absence of subsequent offending. So, I mean, That's the point, isn't it?
Well, that is what is said in HA, but things move fast in this court, and I will take you in a moment to the decision of AA, which came out afterwards, in which the Court of Appeal actually commended the First Tier for its capacity and identified its capacity.
Do you need to? Because it says here it will vary from case to case. I think it would be a very brave tribunal judge with respect, or even a judge without any assistance, to come to a view about prospect of reoffending. Rehabilitation is different, but the risk of reoffending, I think that it's a very nuanced appreciation of very, very many factors.
Your ladyship is absolutely right, but just before we look in a small amount of detail at HA, in answer to that proposition, the factors which do fall to be evaluated are fairly well settled. And when you look at the First Tier Tribunal's determination, what he does is actually perform his evaluation by reference to the considerations that would inform an OASIS assessment. So he does all of the things that the probation service would and should have done.
Mr. Jones, I think that's quite a bold assertion.
But it is an assertion that I'm making. And
I know it's an assertion you're making, but I don't think with too much support. But there we go.
But my lady, in the context of the evidence as was available both to the First Tier Tribunal and the Upper Tribunal, there were the sources of evidence was the OASIS report from 2017, prepared without any engagement with the appellant or any of those responsible for his management in prison, or the question, consequently with the question of rehabilitation. And against that, an evaluation performed by reference to a preponderance of evidence from the prison service speaking to extraordinary levels of rehabilitation and conduct which is in no way compatible with...
Again, you're going off the point with respect, Mr. Jones. Rehabilitation does not necessarily rule out the risk of reoffending.
It doesn't...
That's the difference. There are two totally different horses there. But I think we do need to move on. We've got your speaking note as to the finding of the First Tier Tribunal. And your point is obviously that the Upper Tribunal should have had due regard to that.
Well, the further point I make on that, by reference to HA Iraq and paragraph 142, is that the Court of Appeal in HA Iraq has expressly disapproved the position that was described in Bimbuga, and has done so by reference to a thorough evaluation preceding authorities, which it very respectfully observed was not undertaken by the court in Bimbuga.
Well, I don't read.
Well, the part I'm referring to, my lord, is page 142, 350, paragraph 142. The second sentence, I think, I cannot in any event adopt its reasoning that rehabilitation will normally do no more than show that the individual has returned to the place where society expects him to be, which is precisely the line that the Upper Tribunal in this case used in its judgment. The court goes on in HA to say, notwithstanding its endorsement in Bimbuga, I do not think it properly reflects the reasons why rehabilitation is in principle relevant in this context, which is that it goes to reduce one element in the weight of the public interest in deportation, which forms one side of the proportionality context.
But I don't read paragraph 29 of the Upper Tribunal's decision as going really any further. It says in terms that he's made laudable efforts to rehabilitate, but his overall risk of reoffending must be taken into account, which is my lady's point. They're two different things. And we're satisfied that the history, the nature of his offending means he remains a medium risk. So the point doesn't go any further than that, so it doesn't really...
Well, rehabilitation...
I don't see how this helps you.
Well, as your ladyship has pointed out, there are two elements to rehabilitation and reoffending, and both are capable of impacting upon the public interest side of the equation. And if the Upper Tribunal has diminished the weight going to rehabilitation because it misdirects itself with regard to the effect of Bimbuga, then it has reduced a consideration which goes into the frame. And with regard to reoffending, make this observation: the First Tier Tribunal, on a very comprehensive evaluation of the material, its conclusion as to risk. And it stayed within the medium risk category, but it placed the appellant at the bottom end of that category. And the Upper Tribunal identifies nothing in that finding which is erroneous or flawed in law or fact, and yet it does not apply that principle in its evaluation.
No,
And that is an error.
What paragraph 29 says is that it does draw a difference between rehabilitation and risk of reoffending. And it notes the rehabilitation. The appellant has made laudable efforts to progress his rehabilitation, but his overall risk of reoffending must take this into account. We are satisfied that the history and nature of his offending in all the circumstances is such that he remains at a medium risk of reoffending. And we have got to give credence to the distinction with respect. So it also goes on to say, if the probation service had materially altered its analysis of risk from the 27th OISIS report, we would have expected this evidence to be placed before us and drawn to our attention.
Well, again, that comes back to what the appellant understood. The context of the evaluation was
yes,
to be.
and we've been there before.
We have.
Yes, okay. All right, thank you. So where do we go now, Mr. Jones?
So first, that's our first point on the rehabilitation, that to whatever extent the court regards it as to be, there have been findings of fact which are incompatible with the first tier's retained findings as to the quality of the risk of reoffending, which the upper tribunal has effectively gone behind, or at least not replicated in its evaluation. Medium offending the definition of medium risk, rather, of offending is a broad spectrum, and the first tier has placed him at the bottom end of that spectrum. The upper tribunal's indication offers nothing as to where it places him, and that is an error, because that plays into the public interest. And secondly, the upper tribunal has endorsed a legal analysis in the case of Bimbuga with regard to the implications of rehabilitation, which has been disapproved of. In regard to the
well, you've just got two Lord Justices, as Lord Justice Hamlin was at the time, looking at a different side of the same coin, perhaps, or a different, expressing a different view, but HA doesn't overrule.
But with respect,
CI,
and I don't want anything to be said to be suggesting any lack of respect for the disposal in Bimbuga. We can put that transcript before the court, but I'm sure the court probably has access to it anyway. But the evaluative exercise performed by the respective courts is completely different. There is no analysis of preceding case law with regard to the implications of rehabilitation for the assessment of public interest. In the former, there is a comprehensive analysis of it.
So that's how you distinguish it?
That is how I distinguish it.
Yes, all right.
Lady. And also because what is said by the court in HA is consistent with a preceding line of authority, whereas what is said by the court in Bimbuga is derived from a single judgment of the upper tribunal in the case of RA, which is the very subject of the appeal in HA.
We have to come back to the facts. The court in HA still acceded to the point that this is going to be a variable factor in all cases. In this case, the upper tribunal determined that laudable rehabilitation did not in any way diminish the risk of reoffending.
But having expressed and directed itself in a way that rehabilitation is unlikely to have a significant bearing in any event.
No, it doesn't say that. Paragraph 29 does not say that. Mr. Jones.
Lord Justice Hamlin simply says rehabilitation involves no more than returning an individual to the place in society expects him to be. So he's making a point as to the scope, whatever the findings are, of the analysis, and then the court goes on to consider the analysis. My lady says it's a separate point
But even if
Bimbuga is making.
Even if Bimbuga were right, it still matters. Because if a person who is a criminal offender is returned to a point in society where they're supposed to be, which is no longer a risk of criminal offending, then that is relevant to the public interest side of the equation. In a sense, you know, the court's direction in Bimbuga misses the point.
No, it doesn't, with respect. The point in Bimbuga is that rehabilitation involves re-establishing life outside of prison, if you like, into the community. the risk of reoffending, as with all of us, whether or not, can then be assessed on a scale. One of the points on the scale is whether or not there's a history of offending in the past, which has been interrupted by whatever forces beneficial to the individual concerned, lessens or mitigates that risk. But I think we've got your point,
You have a point.
Mr. Jones, that you say that the upper tribunal were wrong to reappraise the risk of reoffending because they ignored the rehabilitation point.
But they also ignored the finding of the first tier, which they claim to be
Well,
wrong.
we've already been over that as to whether or not they're shackled or not. It's now 12:59. How much longer have you got?
I think I can probably finish in half an hour.
Well, I'm going to hold you to that because we do have to get.
I'm very conscious that my friends have been very gracious. I will
Yes.
motor through the remaining parts of my submissions.
Well, what I suggest you do, please, with Miss Simak this lunchtime, is to look at the remaining, is it 7 pages of your submissions and to focus really on what you want to clarify from that. Because of course you will have and will want the opportunity to respond to Mr. Malik's points, presumably. So, thank you, Mr. Jones. Mr. Malik, do you have any idea how long you may be in your oral submission?
Not more than an hour, milady. So if I start at 2:30, I'll be done. I'm pretty sure
By
by
3:30.
Yes.
All right, yes. Well, in both cases, we have been assisted by the skeleton arguments beforehand, and we'll take away your speaking note, Mr. Jones, so that we can read ahead.
I'm grateful.
So 2 o'clock, please.
Thank you.
Court rise.